So here we have notice. It says notice of hearing. Attorney for Mike Maricini is Omar Serrato, also known as the Tilted Lawyer here on the YouTubes. They are making a motion to disqualify counsel. And then that is pretty much it for these pages. Also, checked the box of other orders requested, which is motion to disqualify counsel, and then facts to support the orders I requested are listed below. The facts that I write in support and attach to this request cannot be longer than 10 pages unless the court gives me permission. He checked that and said, please see attached. And then it is signed by his lawyer on August 25th, 2025. And then it's signed and viewed there. And then we get to the motion. So notice of motion and motion to disqualify petitioner's counsel. So he sought a motion. He notified people that he wanted to make a motion about this. And now we have the motion to disqualify petitioner's counsel, David Gingras, memorandum of points and authorities, declaration of counsel, and proposed order. This is in the Superior Court of the State of California of San Francisco in Owens versus Maricini. To petitioner Laura Owens and her attorney of record. Please take notice that on October 10th, 2025 at 8:30 a.m. in the Department 405A of the San Francisco County Superior Court Family Division, located at the address, respondent Mike Maricini will and hereby does move for an order disqualifying David Gingras, Esquire, from representing petitioner Laura Owens in the pending domestic violence restraining order, also known as a DVRO, renewal proceeding in this action. The motion is made on the following grounds, each an independent basis for disqualification. 1. Conflict of interest. California Rules of Professional Conduct 1.7. Mr. Gingras has a personal conflict of interest that materially limits his ability to represent petitioner. He is subject of a pending state bar disciplinary proceeding arising out of his conduct towards respondent, so towards Mike Maricini. In this case, a state bar court order of probable cause has been recommended. Gingras has stated that he intends to use this case to elicit testimony from Maricini that will aid in his defense in the investigation into his misconduct against Maricini. And if he has actually said this, that is appalling. And we've said this a bunch of times in the videos. And if Laura would listen to everybody that she thinks is a cult when we're not, she would know when it comes to Gingras representing her, he does not have her best interest in mind. Everything Gingras has done is for personal gain, his own personal gain. He wants to make a Supreme Court argument. He wants to have these different types of cases. He wants to be somebody, which he's nobody, but he wants to be. He wants to save his ass by being in on this case. It's not to help Owens out because he believes in Owens. No, it's because he wants to protect his own ass. But his selfishness has gotten him where he is. And he deserves to be in the position that he's in after all the shit he has pulled. And he's openly admitted. I mean, thank you for being so stupid, but really? You're not supposed to say the quiet part out loud, sir. Mr. Gingras' personal interest in defending his own conduct and license creates a concurrent conflict of the interest between his interests and those of his clients. Yeah, because his interests are they are going to be more important than Owen's interests. He can't represent her while he's trying to still kind of represent himself and gather facts. And in violation of Rule 1.7 of the California Rules of Professional Conduct. Okay. 2. Advocate Witness Rule, California Rules of Professional Conduct 3.7. Mr. Gingras is a necessary witness on pivotal contested factual issues in the DVRO renewal hearing. Specifically, his alleged misuse of law enforcement to have respondent, Maricini, arrested on a baseless charge of violating the DVRO, which is also the subject of the bar complaint involving Maricini, for which the Arizona State Bar has recommended an order of probable cause. Mr. Gingras' dual role as advocate and witness contravenes Rule 3.7, the advocate witness rule, which generally prohibits an attorney from acting as trial counsel in a matter where he is likely to testify on a material matter. And maybe he wasn't going to be her attorney on this case. This is the steps that you need to make sure that he doesn't and can't. They might have been trying to go down that route, but or it could have just been he was going to be there for initial appearance type things on this, and that was it. Like he wasn't going to do anything else. He might have just been doing this particular thing, but we know they like to skirt around things. Um, okay. None of the narrow exceptions to this rule apply here, as Mr. Gingras' testimony relates to a hotly contested incident central to the case, not an uncontested issue or a mere formalities. Petitioner contests, if any, to Mr. Gingras' dual role does not resolve the problem. Courts retain discretion to disqualify an attorney, witness, notwithstanding client consent, to prevent prejudice to the opposing party or confusion of the fact finder. And then he cites a case from California, uh, which is Dovey Yem, 55 Cal, Pellet 5th, 573. Courts may remove counsel even with informed written consent to prevent prejudice and protect the judicial process. The advocate witness rule exists to avoid jury confusion and conflicts between advocacy and testimony. And then there is Geringer versus Blue Rider Finance. It's a 2023 case. The court reiterated that courts retain discretion to disqualify an attorney under Rule 3.7, even with a client's consent to protect the integrity of the judicial process. The court emphasized that the disqualification must be based on a convincing demonstration of prejudice to the opposing party or injury to the judicial process. So basically saying, even if Owens was to say, well, I don't care if he's a witness and an attorney, I still want him to be my attorney, so I'm okay with that. It's saying, even if the client says it's okay, if in a fair trial, which is what Gingras and Owens always scream about, they want fair trials, that it is in her best interest not to have an attorney who's also a witness. So the court may say, you know, Your lawyer is not doing what's in your best interest, so we are going to do it for you. Number 3, prejudice to respondent and threat to trial fairness. Allowing Mr. Gingras to continue as counsel under these circumstances will prejudice respondents' rights and undermine the integrity of the proceedings. Mr. Gingras' personal stake in the outcome, avoiding self-incrimination or further discipline, creates a risk that his advocacy is driven by self-interest rather than his client's best interest, which I've kind of been explaining. So me and Omar are on the same page. His presence as trial counsel will also force respondent to confront and possibly cross-examine Mr. Gingras as a witness, an inherently prejudicial scenario that blurs the lines between argument and evidence. This dual role could mislead or confuse the court and impugn the integrity of the judicial process, which the court has a duty to safeguard. Can you imagine Owens asking Gingras questions when he is on the stand? Well, Omar would get to cross Gingras, which he's probably going to get to do anyways, but we shall see. This motion is and will be based upon this notice of motion and motion. The attached memorandum of points and authorities, the concurrently filed declaration of Respondent's Counsel Omar Serrato, all pleadings and records on file in this action, and such further evidence or argument as may be presented at or before the hearing on this matter. Signed, dated August 25th, 2025. Respectfully submitted. Memorandum of Points and Authorities. Number 1, Introduction and Background. Petitioner Laura Owens obtained a temporary domestic violence restraining order, DVRO, in the Superior Court of California, County of San Francisco. Case number. The order was granted on January 10th, 2018. The parties entered into a stipulated agreement resulting in a 2-year restraining order after hearing under Family Code 6200. The order was expired on July 10th, 2020. The order issued without admission of wrongdoing by respondent. So he did not admit and stipulate saying, yep, I agree. Yeah, we'll just do this. So that's good that he did not admit to doing any of this stuff. He just was like, yeah, I'll stay away from her. It'd be nice if she would stay away from him, though, right? Petitioner filed a request to renew the DVRO. A hearing was held before the Honorable Sharon Reardon over respondent's objection, and without a finding of abuse, the court granted a 5-year renewal pursuant to Family Code 6345A, extending the DVRO until July 10th, 2025. Petitioner filed a second request to renew the DVRO against respondent in San Francisco Superior Court on July 10th, 2025. So she just keeps filing them. And while the renewal or the beginning one shouldn't have even been granted, in my opinion, based on everything that we know as of right now, it shouldn't have been granted. The renewal for that definitely should not have been granted, because all of that hogwash she stated in that one was he ran into people that I know, but he never actually ran into me. Okay? Whole purpose is not to be around you, and he wasn't. And Buttons, I believe. Can't be around you or Buttons, the dog. I know it's been a while since we've heard about Buttons, but that's it. And Mike even objected and was like, no. But the court was like, too bad, we're giving it to her. What is wrong with these people? This is why we cannot believe all women because of people like Laura Owens and judges, especially in family law, need to start taking some of the guys seriously. Once upon a time, it was all about, oh, believe the woman, let's side with the woman. Oh, they're just weak little measly people. No, there are some manipulative, vindictive twats out there. And men that are trying to do right. And women can't, some of these women cannot take no for an answer. And so they get mad and they make accusations because they know people will believe them. Continuing on. A hearing was held on August 15th, 2025, whereby attorney David Gingras appeared for petitioner Laura Owens. At the hearing on August 15th, 2025, David Gingras has since indicated to counsel Omar Serrato, both verbally and in writing, that he does not intend to represent Laura Owens in the proceedings. The motion is to ensure that he is in fact disqualified from representation due to a major conflict of interest. This motion is expected to be unopposed by petitioner. So Owens should just be like, yeah, he's not going to be my lawyer. Now, whether they were going to try that or not, and now that it's being brought to the attention, they're just like, yeah, no. Does this motion and knowing about this motion, is that part of the reason that Gingras rage quit on Owens? Like, or, I mean, could this be one of the reasons? Because Gingras would have known about this filing long before, maybe not long before, but before it was filed, I believe. David Gingras' history with Mike Maraschini. Gingras attempted to illegally engineer respondents' wrongful arrest during the DVRO period by misusing the restraining order in this case, involving law enforcement under false pretenses. Maraschini was lawfully subpoenaed, Exhibit A, subpoena to appear, to testify at trial in Maricopa County, Arizona, scheduled for June 10th, 2024, in a case number. That was the Eckerd case. As admitted by David Gingras in his declaration to this court regarding the instant renewal, he was aware there would be legal consequences for his failure to obey the subpoena. So there's an excerpt here. Finally, please note that it is a felony under Arizona law for any person to unlawfully withhold testimony, to evade legal process, to appear, and or to fail to appear when legally summoned. For avoidance of any doubt, nothing in this Exhibit B, David Gingras' declaration, page 7, paragraph 28. Then Omar continues to say, it is doubtful that David Gingras, who has been in practice for roughly 25 years, has a profound misunderstanding of the law, that he reasonably believes that Maraschini violated the DVRO by complying with a validly issued subpoena. Yet he cites in his declaration Arizona Rule 49 regarding discovery disclosures as a valid basis to threaten Maraschini with arrest in an email to David Woodnick. It's supposed to be Greg Woodnick, but we will give grace. And here's the excerpt from there. P.S. This goes without saying. To the extent I suggest Mike would be arrested if he comes to court in Arizona, the suggestion is completely and totally withdrawn. I only said that because I didn't want Mike to show up without giving me a chance to at least interview him as I would with any normal witness. So you threatened him and tried to intimidate a witness in a case where you're a lawyer on to get what you wanted. But oh, you don't like unethical lawyers. You don't like unethical people. But witness intimidation as a lawyer in a case that you're a part of is pretty unethical. You're a hypocrite, Gingras. He says, as long as Mike agrees to have a reasonable call to answer some questions, I'll stipulate and agree his appearance in Arizona is not in violation of anything and will not expose him to arrest or any other legal consequences. So if he does what I want, I won't call the cops on him. If he doesn't do what I want, I'm going to call the cops on him. It's not about Owens was scared that he was there. It's they didn't get what they wanted. So they're throwing a hissy fit and trying to make other people's lives miserable. They can act like it is a part of her being scared and everything else, but he states it here in black and white. Do what I want or else. Not in those exact words, but pretty much. This is Exhibit D, excerpt from David Gingras to Attorney Greg Woodnick, dated May 8th, 2024. Oh, he is excerpt too. All right. The issue regarding Maricini's testimony was addressed in a motion in limine filed by Greg Woodnick and addressed by Judge Mata during the trial of Owens v. Eckerd. Response/objection to petitioner's motion in limine, David Gingras argues in his declaration a violation of Arizona Rule 49 regarding disclosures as the reason law enforcement was called, which Woodnick refutes and offers the basis behind Maricini's expected testimony. Namely that Mr. Maricini's testimony is important to show her motive, intent, plan, preparation, knowledge, and absence of mistake. There was an extensive litigation in San Francisco regarding these parties. Owens claimed to Maricini that she was pregnant with his twins, that she miscarried, quote unquote. That she needed to take abortion pills, have a D&C because she had a severe allergic reaction to the abortion drug, and that only one of the fetuses was terminated. So apparently if you have an allergy, it only kills one baby, not two babies. If you only have one baby, I guess it just terminates it. But if you have twins, the allergic reaction is it only gets rid of one and not two. According to Laura. I don't know what other allergic reaction she had. I don't think she took any pills because she wasn't pregnant, in my opinion. Laura also allegedly told him that she had ovarian cancer. So when David's like, I don't know what he's going to testify to. They're supposed to tell me what he's going to testify about. You were told what he's going to testify about. You are a liar. And that she had to have an ovary removed, fabricated medical records to support this, claimed that she might have cervical cancer, and that she might have Asherman syndromes and Crohn's disease. The thing is I don't necessarily want to see any more of Owen's body, but if she had an ovary removed, she is either going to have a scar on her belly button where they did laparoscopic, or she's going to have a C-section like scar above her hoo-ha because they weren't able to remove it laparoscopically. I had one ovary removed when I was 13. And they tried to do it laparoscopic because that's the way they would normally do it. Mine was my ovary situation. It had a softball-sized cyst on it. It had twisted and caused, torsion, and it had killed my ovary. But because it was so big and all the surrounding circumstances, it wasn't going to be able to be done laparoscopically. So they had to do like a C-section, cut open, and take it out that way instead. So if she had an ovary removed, she would have one of those two scars. She doesn't because she has both of her ovaries still, as she has said. But back in 2018 or 2017, when she's making up lies, she said this. She should have had scars from this procedure. There would have been things she can't do. There would have needed to be some wound care. But she didn't have this stuff done. And, guys don't always know the different things for that. But that would have, shown it right there. Let's see your scars if you had this done. That's what Mike should have said. But it's not his fault. He doesn't know about some of this stuff. I only know about that part because I've had it done to myself. All right. Laura, after seemingly realizing that Maricini provided relevant information in the instant litigation, has since claimed that the medical records Maricini provided, disclosed to Laura, were fabricated. Ostensibly, Maricini was distressed by Laura via counsel, posting the 2018 deposition and blogging about him being a liar and 100% false, which led him to surrender his laptop to a San Francisco-based computer forensic expert, John Berryhill Computer Forensics. Exhibit 2, Mr. Berryhill analyzed thousands of pages of text messages and medical records communicated between Laura and Mr. Maricini and determined that all text messages, medical records from Laura, a phone number came from Laura, meaning Laura appears to be continuing to commit perjury by filing affidavits that disclaim texts and medical records that she sent. It is no wonder she does not want Maricini addressing her intent, motive, knowledge, absence of mistake, and preparation, despite his testimony being admissible under the rules. Exhibit E, page 7. All right. Gingras attempted, that is things that were said by Woodnick, I believe. Gingras' attempt to harass Mike Maricini through social media, through his former attorney, Randy Sue Pollock, and ultimately with the Phoenix PD in effort to intimidate a witness into not testifying at trial. Exhibits F through R. Social media posts where David Gingras taunts Maricini in social media, emails to counsel, and in his personal blog published by Gingras' website both before and after June 10th, 2024 trial. When Maricini arrived as directed in the subpoena, David contacted the Maricopa County Superior Court Security Department to advise them of the situation. He then contacted court security to explain the situation and to ask them to enforce the court's order. The Phoenix Police Department arrived shortly thereafter, where David provided them with a copy of this court's order and asked them to enforce the order as required by federal law. Exhibit B, David Gingras' declaration, page 10, paragraphs 36 through 40. He's like, this is what I'm saying. Here are the receipts. Because Omar has the receipts. A huge scene was made shortly before the trial began because of a large presence of law enforcement. Gingras' transparent attempt to witness intimidation became moot as Maricini, although named witness, was not called to testify. Yeah, because they only had 2 hours. There was not enough time. That incident, which respondent contends was a bad faith abuse process by Mr. Gingras, is a central disputed issue in petitioner's request to renew the DVRO. Mr. Gingras is a recipient witness to the event, and his credibility and conduct are directly in question. Compounding this, Mr. Gingras now has a personal stake in the case beyond his role as an advocate. Respondent filed a state bar complaint regarding Mr. Gingras' conduct in this matter. The Arizona State Bar independent review has resulted in a recommended order of probable cause, meaning the bar is proceeding in its investigation under the belief it has sufficient evidence of ethical violations by Mr. Gingras towards Maraschini to initiate formal disciplinary proceeding. Exhibit C, notice recommending a finding of probable cause. He enters the DVR renewal hearing with a serious conflict of interest. His own professional faith is at risk based on the facts of this case, creating strong incentives to vindicate himself or minimize his wrongdoings. Much of the basis for Owen's renewal request is focused on Gingras' personal grievance against Maraschini and has little, if anything, to do with Owen's reasonable fear required to move forward with her request. California law holds paramount the duty of attorneys to avoid conflicts and to maintain the integrity of the judicial process. Whereas here, an attorney's personal interests material limit his representation and where the attorney is likely to be a necessary witness on contested issues, a court both the authority and the obligation to disqualify counsel in order to preserve public trust and fairness of the proceeding. And then he cites some cases. Yeah, he's a witness. And Owens, was there as an observer, and there were many other observers who saw this, but David Gingras was the one who made the call. And so he has to testify about the things that he did. We can say, yeah, we saw him on the phone. And then later the police came. And so based on what we heard from the phone call and then the police showing up later, we can conclude that that's who we think that David was calling. But he can say, yeah, I called them. But because we are going to have to get around some hearsay stuff too. That's why Gingras needs to testify. He'll probably lie and say the bullshit that he's been trying to say since the date of June 10th. All the hogwash, bullshit reasons that make no sense whatsoever. Respondent does not bring this motion lightly, recognizing that the parties are generally entitled to counsel of their choice. However, the California Supreme Court has emphasized that the importance right to counsel of one's choice must yield to ethical considerations that affect the fundamental principles of our judicial process. Great Lakes Construction Incorporated versus Berman, 2010 case. In short, the paramount concern must be to ensure a just proceeding untainted by conflict or an attorney's self-interest. Accordingly, respondent moves to disqualify Mr. Gingras, whatever his name is, Dingus, douche canoe, whatever, on two primary legal grounds. One, conflict of interest, Rule 1.7, and two, advocate witness, Rule 3.7. In combination, these factors demonstrate that allowing Mr. Gingras to continue as counsel would prejudice respondents' right and the integrity of the court. I agree. Legal standard for disqualification of counsel. California courts have inherent authority to disqualify an attorney when necessary to protect the integrity of the judicial process and the rights of litigants. A motion to disqualify involves a conflict between the affected party's right to chosen counsel and the duty to uphold ethical standards in litigation. The court's paramount concern is preserving public trust in the scrupulous administration of justice. Therefore, the important right of counsel of one's choice must yield ethical consideration, where those considerations are fundamental to fairness of proceedings. Citing some cases, disqualification is warranted for a variety of ethical violations, but two grounds are particularly relevant here. And the first one he talks about is concurrent client conflicts, personal interest conflicts. Under Rule 1.7 of the California Rules of Professional Conduct, an attorney must not represent a client if there is a significant risk the representation will be materially limited by the lawyer's own personal interests, absent informed written consent from the client, which he has a personal interest in this case for his own well-being. Even with the client's consent, some conflicts are so severe that they are not truly waivable if they threaten the fairness of the proceedings. The court may disqualify an attorney whose personal interest conflict poses a substantial risk to his ability to represent the client in order to protect the interest of justice, will be materially limited by lawyer's responsibilities to or other relationships with another client, a former client, or a third person by the lawyer's own interest. We agree with the trial court's analysis. Simonian has failed to establish the court's abuse its discretion in denying his motion for reconsideration or in denying him to leave to amend the complaint. The other one is advocate-witness conflict, Rule 3.7. A lawyer may not serve as both advocate and a witness on a material issue at a trial, absent narrow exceptions. This advocate-witness rule exists to avoid prejudice and confusion, as California courts deem the dual roles irreconcilable, requiring partisanship as counsel objectivity as a witness, thereby undermining fairness. Even if the client were to consent to such a dual role, the court retains discretion to refuse to allow it, to protect the trier of fact from being misled or opposing party from being prejudiced. And then he cites the case. In deciding a disqualification motion, the court must examine the totality of the circumstances and determine whether the attorney's involvement would have a continuing effect of the proceedings, such that the fairness or appearance of fairness is jeopardized. Citing another case, when an attorney's continued representation threatens to undermine the integrity of the judicial process or impacts the moving party's interest in a just determination of the case, the court must exercise its discretion to disqualify the attorney. Ultimately, the trial court has an independent interest in ensuring trials are conducted within ethical standards and that legal proceedings appear fair to all who observe them. This independent interest exists regardless of whether the attorney's own client objects to the conflict, even if non-client litigant, like the respondent here, has standing to seek disqualification when the attorney infects the litigation, and threatens a cognizable interest of the moving party in fair proceeding. Against the legal backdrop, both prongs of Mr. Gingras' conflict are squarely presented in this case. We address each in turn. Also, Judge, a PS from the JFC, now the JMC, JFC, Justice for Cult here. So it's not going to be Justice for Clayton, it's just the Justice for Cult, JFC. We're going to be doing Justice for Mike Maricini in our JFC Cult. And we would like to warn you, or tell you, Judge, having him off the case as an attorney is also in your best interest. We aim in the Justice for Cult to save you from mind-numbing headaches, lots of wasted time, and wanting to strangle people. We are concerned about your mental health as well if you let this attorney and this petitioner, Owens, the Owens Gingras team go at this together, you will probably regret it, because I don't know if you've seen anybody like this duo. You've seen a lot of things, but this is something you don't want to deal with. So, justice for Colt is trying to have justice for you, Judge, as well, for your own peace of mind. Signed, JFC Colt members. All right. Argument A. David Gingras' personal interest in avoiding discipline conflicts with his client's interest. Rule 1.7, conflict of interest. Gingras' ability to represent petitioner with undivided loyalty and independent judgment and material compromise by his own personal interest in this matter. Rule 1.7b defines a concurrent conflict of interest to include situations where there is a significant risk the lawyer's representation of the client will be materially limited by the lawyer's own interest. That is precisely the situation here. Gingras' personal conduct regarding respondent is under official scrutiny, and he has a powerful incentive to protect himself, to defend his reputation, and to avoid professional discipline arising out of this case. This creates a significant risk that his representation to Miss Owens will be skewed or impaired by considerations or self-preservation. The American Bar Association, Rule 1.7, Conflict of Interest, Current Clients, comment, and then AmericanBar.org. Yeah. He's going to want a CYA. Cover your ass. Gingras is going to try to cover his ass. Because he can say, oh, I want to quit. But it's a lot like Gingras throwing his thing that's like, well, I want to get away from the Arizona bar anyways because I have my issues with it. It's amazing you didn't have issues with them before. But, when somebody says you're fired, Gingras is the type of person that would be like, well, I quit. Well, that's great, but you've been fired before, so whatever. He's like, well, I don't want to be a part of the Arizona bar anyways. I want to leave on my own terms. So, I mean, if they disbar me, it's okay because I was wanting out anyways. Sir, you were not planning on when you took this case ending your career as a lawyer. But now that you're in trouble and it's so close and you're being investigated for things, now all of a sudden you don't want to be a lawyer there anymore. If you would have just kept your mouth shut and acted as a lawyer and done things in court, you would not be in the situation you're in. But you wanted to try to be a PR person who is very bad at it and an attorney. And you got too close to your client, in my opinion. Instead of it being a business transaction, they're just a client. And I get you can become close with clients, and some clients can end up like family because you get to know them so well. But I mean, it was like a year. And you saw all the things. So I don't know what your vested interest in this case was. Like, I know you thought you could come in and Rule 26 it, but like that should have been it. I don't know what your attachment is to this family or to her. It's bizarre. But now all of a sudden that you're in trouble, you don't want to be a lawyer anymore. Or at least in Arizona. That is precisely the situation here. Gingras' personal conduct regarding respondent, which is Maricini, is under. Oh, okay, we already read that. Okay, the Arizona bar probable cause finding is an objective indicator Gingras conducted in this matter is in serious question. When an attorney's own actions are at issue in the case, Ethical authorities warn that it may be difficult or impossible for the lawyer to give a client detached advice. Yeah. An attorney cannot be neutral or wholly loyal when his personal wrongdoing is intertwined with the client's case. The lawyer's own interests should not be permitted to have an adverse effect on the representation of a client. So he's saying Gingras' own self-interest here is not supposed, it should not, in fairness to Owens, have an effect on Owens' representation. Owen should have better representation and not somebody who's intertwined with her case and became involved in it. He should have just been a neutral party, not necessarily neutral, just her lawyer, and that's it. And he wouldn't be in this. But he couldn't behave as a professional lawyer. And Omar, to me, in this, is saying in a legal way, this attorney's not good for you, Owens. He is not in it for you. He never has been. He wants something out of you. He is he has taken advantage of you. And yeah, you've met somebody who seems to be a lot like you in certain ways. But two wrongs don't make a right. And Omar is actually protecting you by not wanting you to have this lawyer. It's not because he wants to be mean to you or leave you lawyerless. It's because it is not in your best interest. So to me, Omar is actually looking out for Owens in this. He's looking out for his case and his client as well, but it also serves as a good thing for Owens to not allow this. She doesn't see it that way. Gingras isn't going to see it that way, but I think it is. Here, Gingras alleged misconduct towards respondent, misuse of the DVRO and law enforcement is a central issue. He has a personal stake in denying or minimizing that misconduct. The personal stake directly conflicts with his client's interest in a full and truthful adjudication of the DVRO issues. If certain evidence in the renewal hearing might vindicate respondent's claim of attorney abuse and thereby bolster the state bar's charges against Gingras. Gingras has temptation to downplay or suppress that evidence, even if it might be relevant to Miss Owens' case. Conversely, Gingras might be tempted to overemphasize or even fabricate justifications for his prior conduct to protect himself, evidenced by his major emphasis on the incident related to the Arizona bar investigation highlighted in this declaration. Footnote 3. Laura Owens' petition for the renewal was undoubtedly authored by David Gingras, as his declaration virtually mirrors the facts set forth in Laura Owens' petition. The overwhelming bias of Owens' petition is centered around Maricini complying with a lawful subpoena, where Gingras is alleged to have abused the DVR process and law enforcement to intimidate a witness. Yep. Yes, he did. And we know the difference between Gingras' writing and Owens' writing, because we have read many of things of Medium blog posts written by Owens and blog posts and tweets and court filings from Gingras to understand Owens doesn't speak like a lawyer. Gingras tries to imitate being a lawyer. I mean, he has a bar card and everything, but maybe he tries to imitate being a good lawyer, and he's not. Mm-mm. California courts have recognized that an attorney who is simultaneously defending his own conduct while representing a client in the same matter operates under disqualifying conflict. For instance, an attorney who was disqualified in a family law case, Kennedy v. Eldridge, due in part to his emotional involvement and personal entanglements that compromised his objectivity and loyalty in representing his client, who was his son. Yes, perfect example of what I was trying to say earlier. Gingras has too much personal involvement, emotional involvement, and entanglement in this case with Owens, the Clayton v. Eckerd case. I don't know why he has an emotional involvement, personal entanglements, personal interest, connection, all that to this case and to Owens, but he does. That's what is bizarre to me because I just don't get it. The court noted that such multiple roles and personal stakes undermine the integrity of the judicial system and create at least an appearance of impropriety that cannot be ignored. Yeah, that's why a lot of times you're not supposed to represent family members um, because you have a personal interest in it. You have a bias. You want your personal family member to win. Um, just like doctors, they sometimes you can blur the lines when you have personal interests and entanglements and stuff involved with clients and patients. And so we cannot allow this stuff. That's why there are rules against it. Let's see what else he says. A client consent to conflicted representation does not bind the court when the conflict threatens the fairness of the proceedings. Court reserve the power to disqualify an attorney if the conflict poses a substantial risk to the attorney's ability to completely and loyally represent a client, or if it undermines the adversarial process, notwithstanding the client's willingness to proceed. As the California Supreme Court has observed, some conflicts are so severe that even informed consent may not suffice. To avoid prejudice, especially where an attorney's judgment may be impaired by personal considerations. His judgment is impaired for many reasons. His own self-interest, drinking, possibly drugs, underage girls, lots of reasons that Gingras' judgment could be impaired in a case. But I digress. In this case, disqualification on conflict of interest grounds is warranted because Gingras' personal interest in his own disciplinary outcome is paramount and irrevocably at odds with his client's interest. The situation creates, at the very least, an appearance of impropriety and a genuine risk that Miss Owens will not receive unbiased, conflict-free representation. No, she will not. She definitely doesn't have conflict-free representation. The integrity of the court's process is likewise at stake. The fact finder should not have to wonder whether petitioner's counsel is shading his advocacy to save himself. In short, Rule 1.7 prohibits Gingras' continued representation, and the court should exercise its discretion to disqualify him on this basis alone. B. Gingras must be disqualified under the Advocate Witness Rule 3.7. Gingras' role as a key participant witness independently mandates his disqualification. Rule 3.7a bars an attorney from serving as both an advocate and a witness on a contested issue, absent narrow exceptions that do not apply here. The June 2024 incident where Gingras reported responded to police in a misleading attempt to have him arrested with knowledge Maraschini was complying with a lawfully ordered subpoena in efforts to intimidate a witness on the day of trial is central to petitioner's request for renewal. Only Gingras can testify about his own statements and motives during that episode, making his testimony necessary and material. Yeah, Gingras has to be able to testify about it. Courts have long held that the dual roles of advocate and witness are irreconcilable, as one requires persuasion and the other objectivity. Allowing Gingras to continue would create multiple prejudicial effects: one, misleading the fact finder by blurring advocacy with testimony; two, prejudicing respondent, who would be forced to cross-examine opposing counsel; and three, improperly bolstering Gingras' credibility through his dual role, as warned in Comden versus Superior Court 1978, is a California case. Even with client consent, comment 3 to Rule 3.7 confirms that the court retains discretion to disqualify counsel to protect fairness. Citing case again, petitioner can readily secure substitute counsel by respondent's right to a fair trial would be gravely compromised if Gingras remains. The equities, thus decisive, supports disqualification. C. The combined effect of Gingras' conflict and dual role threatens the fairness and integrity of these proceedings. Even if either of those above grounds alone might suffice, together they present a compelling case for disqualification. This is the situation where an attorney's personal interest conflict, Rule 1.7, and advocate-witness conflict, Rule 3.7 interest, compounding the potential for injustice. Gingras' personal interest, his pending discipline, gives him a motive to color the evidence and arguments in this case to suit his own ends. Consciously or unconsciously, this undermines the court's confidence that petitioner's case is being presented ethically and objectively. Simultaneously, Gingras' status as a key witness means he is effectively an unsworn participant in the events being litigated. The fact finder must evaluate Gingras' actions and credibility, yet Gingras, as petitioner's lawyer, would also be packaging those facts for the court. From respondent's perspective, these conflicts materially prejudiced his rights, so Maricini's rights. He faces an opposing counsel who might distort the truth to protect himself, and whose factual claims cannot be tested by normal means, since that counsel also controls what evidence is presented. This is antithetical anti-theatrical to a fair adversarial process. From the court's perspective, the proceedings risk devoting into a trial about Gingras' conduct rather than the parties' issues, creating a sideshow that distracts from adjudicating the DVRO renewal on its merits. Additionally, the court must worry that any decision granting or denying the DVR renewal could be tainted by the perception that one side's attorney had a personal axe to grind, or that the dual role influenced the outcome. Yeah, because if Maricini's bar complaint is one that caused him to be investigated and for him to lose his bar license and dishonorably be discharged, basically, yeah, Gingras would have a personal axe to grind. Because Gingras will say that it is Maricini's fault for lying to the court, writing things that didn't happen, and all of that, instead of looking within himself and realizing that he did this to himself. Additionally, the court... we read that. And they cite a bunch of cases. In sum, allowing Gingras to serve as petitioner's advocate would materially compromise the fairness of the DVR renewal hearing. It would place respondent in an unfair disadvantage, interjecting Gingras' personal issues into a proceeding that should be about the parties, not the lawyers. Correct. The prudent and just remedy is to disqualify Gingras now before the trial to ensure that the upcoming hearing can focus on the merits with both parties represented by conflict-free counsel and all witnesses, including Gingras, testifying without also acting as advocates. Conclusion. For the reasons, Respondent Mike Maricini respectfully asks the court to disqualify David Gingras, Esquire, from representing petitioner Laura Owens in the DVRO renewal. Disqualification is necessary to eliminate a clear conflict of interest, enforce the advocate witness rule, and preserve fairness of the proceedings. If needed, the court may briefly continue the hearing to allow petitioner to retain new counsel, ensuring that the matter is resolved on the merits without ethical compromise. So they're saying, we will agree to extra time so that she can try to find herself another lawyer if need be. Because we are wanting to take away her lawyer. It is in her best interest, but, so she has counsel. By removing Mr. Gingras, the court affirms that justice must not be clouded by attorney conflicts or dual roles, thereby safeguarding both parties' rights and integrity of the tribunal. Respectfully submitted, Omar Serrato, aka the Tilted Lawyer, dated August 25th, 2025. Now in this filing, it is notice of motion and motion to disqualify petitioner's counsel David Gingras memorandum of points and authorities, declaration of counsel, and proposed orders. This still goes with the motion to disqualify petitioner's counsel. It says, I, Omar Serrato, declare as follows. I am an attorney, duly licensed, practiced before the state of California, and counsel for respondent Michael Maricini. Or Michael Maricini. Anywho. In this action, I have personal knowledge of the facts set forth in this declaration, and if called as a witness, could and would testify competently thereto. 2. This action involves petitioner Laura Owens' request to renew a domestic violence restraining order, DVRO, against respondent Mike Maricini. Having substituted in on August 15th, 2025, the DVRO renewal hearing is currently pending in the San Francisco County Superior Court Family Division. 3. Attorney David Gingras, Esquire, is an attorney of record for petitioner Laura Owens in this DVRO proceeding, having substituted in on August 15, 2025. Mr. Gingras has been representing petitioner through the DVRO case and is expected to act as petitioner's counsel at the upcoming renewal trial if not disqualified. He has also been her counsel in Maricopa County, Arizona, where he represented her in a case, Clayton v. Owens v. Eckerd, where Michael Maricini was a subpoenaed witness. 4. I'm informed and believe and thereon declare that Mr. Gingras is a recipient witness to significant disputed events underlying the DVRO matter, in particular on or about June 10, 2024, during the period that the current DVRO has been in effect. Mr. Gingras contacted law enforcement and reported an alleged violation on the restraining order by respondent Mike Maricini. Mr. Gingras had reported led to law enforcement officers confronting Mike Maricini. No charges were ultimately filed, nor was he arrested for any violation against respondent as a result of the incident. I believe also there's a report from then, or times that she keeps trying to get the police to say he violated it. And the police, in multiple police reports over this time period, say, we do not see a violation. No violation. That's from the police. I know the police aren't the final word, but police aren't finding it. That the things that these men have done, or really not done, because she just makes it act like they've done something to her and they haven't. The police are like, we don't see where they have violated their restraining orders. Like, nothing they're doing is they're not doing anything they're not allowed to do. 5. Respondent's position is that the above incident was false or exaggerated claim orchestrated by Mr. Gingras to harass or intimidate respondent. Respondent disputes that he violated the DVRO at all and contends that Mr. Gingras misused his role as petitioner's attorney by involving the police without a valid basis. The incident and the parties' conflicting accounts of it is expected to be key issue at the DVRO renewal hearing. Petitioner, through Mr. Gingras, has cited respondent's violation of the DVRO as a reason the restraining order should be extended, while respondent will argue that the incident shows an abuse of process by the petitioner's side. I am informed, number 6, I am informed and believe that Mr. Gingras has personal knowledge of and involvement in the aforementioned incident. Mr. Gingras was the person who spoke to the police, thus he is a necessary witness to explain what he reported and why. To my knowledge, no one else can provide the same testimony regarding Mr. Gingras' communications and intentions in calling law enforcement. The accuracy and account of Mr. Gingras' actions during the incident are directly at issue in determining whether respondent violated the DVRO or whether the incident was a misuse of the DVRO mechanism. 7. Respondent Mike Maricini filed a complaint with the Arizona State Bar concerning Mr. Gingras' conduct in relation to the DVRO case. The State Bar complaint focuses on Mr. Gingras' role in law enforcement incident described above, among other related conduct during the case, alleging that Gingras violated ethical duties in his treatment of respondent. 8. I am informed and believe that after an investigation, the State Bar of Arizona are recommending a finding of probable cause to proceed with the disciplinary charges against Gingras, finding that sufficient evidence exists that Mr. Gingras committed one or more violations of the rules of professional conduct in connection with his representation of Petitioner Owens against Respondent Maricini, Exhibit C. 9. As of the date of this declaration, Gingras' State Bar disciplinary proceeding remains pending. I am informed that no final discipline has been imposed, and Gingras maintains an active law license. However, the State Bar proceeding is ongoing and could result in professional discipline, such as reproval or suspension, if the charges are proven. It is my duty to alert the California State Bar of the pending action pursuant to the rules of professional conduct 8.3, reporting professional misconduct. So Omar gets to tell California, hey, Arizona's looking into a lawyer that is licensed here in California. So you might want to take a look at that stuff. I am informed and believe that Mr. Gingras did not disclose to this court the fact that he is facing a State Bar investigation, charges arising from this case. There is no stipulation or waiver concerning this conflict filed in this action. I am uncertain whether or not Laura Owens has provided informed written consent waiving the conflict presented by Mr. Gingras' personal interest in the outcome. In any event, as outlined in the motion, I believe that this conflict is so severe that the fairness of the proceedings would be affected even if consent was given. So, Gingras isn't being forthright. He is not telling the court up front about his involvement with his client. So, and the court's not going to like that you weren't upfront about things, that you were trying to hide things from the court, or you were, omitting things, whatever. The court may not look kindly on that. And they're leaving out a lot of things. She's like, it was horrible. He traveled to another state just to have contact and see me. No, ma'am, he did not. He came because a judge told him to. And then her lawyer's like, he came even though he shouldn't have. They're just not telling the full truth, which is not okay. You need to be fully forthright with all the information, not just the good parts for your side. I believe disqualifying Mr. Gingras will not prejudice Petitioner Owen's case beyond the ordinary inconvenience of obtaining new counsel. We did not bring this motion for any improper purpose or tactical delay. Respondent's sole aim is to ensure that the upcoming DVRO renewal hearing is adjudicated on the merits without the process being skewed by counsel's conflicting interest or dual role. I declare, under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Executed August 20th, 2025 at San Bernardino, California. Respectfully submitted, Omar Serrato, attorney for respondent Mike Maricini. And yeah, Omar's doing this correctly. He wants this to be fair. He doesn't want delays. He doesn't want any bullshit or fuckery going on with this. Because that's all that this stuff has been doing. That's all Owens has been doing for over 10 years. And it needs to stop. And this case needs to be really looked at. And the behavior of the petitioner in it. I am not trying to do anything for improper reasons. But we want this case basically on the facts and the merits of the case. We don't need a whole bunch of other bullshit and her trying to skew systems. Okay. Now we're going to get to Mike Maricini's and Omar's proposed order. Now, this is going to be Omar basically acting as the court in this. That way, the way it's written, the judge can be like, yep, I adopt this proposed order and I'm making it the order. So he is going to be talking like as if he was the court himself. Because they're saying, this is what we propose you say, judge. And this is how it would sound. And while some of this seems repetitive, some jurisdictions, they make you do more steps than others. It also could be just the fact that if you make sure that you take all these steps, you ensure that you didn't miss a step so that later they can be like, well, like Gingras being like, well, they filed this and this and this, but they missed this step. So Omar here doing all these things is making sure that no steps are missed. So while all this stuff has to do with Rule 1.7 and Rule 3.7 in disqualifying Gingras, in the end, we had in all these documents, we had the notice that we're going to file this motion. We had the motion. Then we had, the arguments as in the motions about why this is what needs to happen. Then we have a declaration of the attorney on behalf of his client as well, stating under oath that these are the facts. Then we have, okay, judge, you've heard our arguments, we've filed our motions. Now we're going to give you the idea of what you can rule on. That way it covers all the bases and the judge can just adopt it instead of just writing his own ruling. He can just be like, yep, proposed order is an official order. So let's get into this proposed order. Says the court, having read and considered respondent Mike Maricini's motion to disqualify petitioner, counsel, the supporting declaration of counsel, all papers filed in support and opposition, and the arguments presented at the hearing now rules as follows. Findings. So this is where the judge would put his findings. Number 1, conflict of interest to Rule 1.7. The court finds that attorney David Gingras is subject of the pending state bar disciplinary proceeding arising from his conduct towards respondent in this related matter, for which an order of probable cause has been recommended. This creates a personal interest conflict under Rule 1.7 of the California Rules of Professional Conduct. The court finds that Gingras' representation of petitioner is materially limited to his own personal interest in avoiding discipline and defending his conduct, and that his conflict threatens his ability to render detached and loyal advice to his client. 2. Advocate's Witness Rule 3.7. The court further finds that Gingras is a necessary witness on a contested factual issue in this case, namely his role in contacting law enforcement to allege a violation of DVRO by respondent. The court finds this testimony is material and disputed, and thus Gingras' dual role as both advocate and witness is barred under 3.7. The court also finds that no exception to Rule 3.7 applies, and that even with the client's consent, the court has discretion to disqualify counsel to prevent prejudice and protect the integrity of the proceedings. 3. Prejudice to respondent and integrity of proceeding. This is protecting Owens, basically. The court finds that allowing Gingras to continue representing petitioner would prejudice respondent, as respondent would face the untenable burden of having to cross-examine opposing counsel on material facts. The court also finds that Gingras' dual role risks confusing the trier of fact, blurring the line between testimony and advocacy, and undermining public confidence in the fairness of the proceedings. Now, I think if for some reason the judge decided to allow Gingras to stay on as counsel, or for some reason he came back after quitting, that Omar could handle cross-examination of Gingras and stay within the lines of attorney-client privilege and such. But also the judge could say, well, I'm the trier of fact and I know how to weigh the different things and not to be confused on things. It would be different maybe if this was a jury, and we wouldn't want to confuse a jury, but judges sometimes are like, I wouldn't be confused as the trier of fact. That's the only thing I could see the judge being like, but I think, but I think he can still adopt it as a judge as well. 4, the court finds that petitioner's right to chosen counsel must yield to overriding duty up to the court to ensure proceedings are conducted in accordance with ethical standards and to preserve public trust in the judicial system. Order based on the foregoing findings and good cause appearing, it is hereby ordered that respondent's motion to disqualify is granted. It is further ordered that attorney David Gingras is disqualified from representing petitioner Laura Owens in this matter. It is so ordered. And then there's a line, Judge of Superior Court, dated October 10th, 2025. So it is dated for the future of this hearing. And it's got a line for the judge to sign it if he wants to adopt this proposed order himself. I mean, he can also write his own order, but sometimes in cases, if you watch them, especially in like family court cases, you'll hear a judge say, okay, will you write up this order and I'll sign it. So the judge doesn't write the orders always. One of the attorneys will do it. You'll see it a lot in a pro se thing where if one party is pro se and the other is not, the one with the attorney will write the proposed order and the judge will sign off on it, and then the copies will get sent to everybody that it needs to be sent to. All right. And then Exhibit A is the subpoena in the family law case for the Owens v. Eckerd. And it says you are ordered to appear in the Superior Court of Arizona in Maricopa County at the place, date, and time specified below to testify at a trial in the above named case before the Honorable Judge Julie Mata. It gives the address and the room number on June 10th, 2024, and the time that you need to arrive is 8:45 a.m. Arizona time. And then these are just instructions that go along with the subpoena for the Superior Court of Arizona. Pausing here if you want to read them, and everything like that. And then here's some more if you want to pause and read. And then the last page of the subpoena. Then he sticks in a declaration of David Gingras. Now, this declaration is different than the one he entered in for the Clayton Eckerd case, because this is on the Maricini matter. So, it says, my name is David Gingras. I am a United States citizen, a resident of the state of Arizona, and am over the age of 18, and if called to testify in court or other proceedings, I could and would give the following testimony, which is based upon my personal knowledge. You know what it doesn't say? That the foregoing is truthful. No. I'm going to give these things based on my personal knowledge, meaning what my personal knowledge is could be a lie from my client, but it's my personal knowledge, so I can't guarantee it's truthful. But he did not say could and would testify truthfully based on my own personal knowledge. Thought that was interesting. I am an attorney licensed to practice the law in the state of California since 2002 and in Arizona since 2004. I graduated from the University of San Francisco School of Law in May 2000, where I was a member of the USF Law Review for 2 years. I am an active member in good standing with the State Bar in California, and I am admitted to practice and in good standing with the United States Court of Appeals for the 6th, 9th, and 10th Circuits, the United States District Court for the District of Arizona, and the United States District Courts for Northern, Central, and Eastern Districts of California. While technically this is true right now, he is technically in good standing. In his declaration, he should have put, I am currently under investigation. So I don't know if by technically, according to the website, and the fact that you still have your law license, that means you're in good standing. I don't know if you should say that you're in good standing. Well, in a technicality, it might be true. Saying you are licensed is true. But you also need to let the court know, hey, I'm actually being investigated. Because even if Maricini and Omar were not trying to disqualify Gingras, what would happen if all of a sudden in the middle of this case, Gingras loses his bar card and he's no longer allowed to practice law, and now the case has to be halted because Owens now does not have a lawyer? The judge needs to know about this possibility. Now, I don't think that they would do it in the middle of this. I think they would wait for this case to be over and see what comes out with this to add to their investigation. But it is a possibility. And he's not being forthcoming, which Omar has pointed out in his filings. I previously represented a woman named Laura Owens in a case filed in the Maricopa County Superior Court here in Phoenix entitled Owens v. Eckerd. The online docket for this case is available here, and he links the docket. Owens v. Eckerd was a paternity case Laura filed on August 1st, 2023. In her petition, Laura claimed she became pregnant after a one-night sexual encounter with a man named Clayton Eckerd. When Laura filed the case on August 1st, 2023, she was pro se, and I did not represent her in any capacity. Respondent Clayton Eckerd was also pro se. Nobody cares if in that case that person didn't have a lawyer at the time. That stuff, who had a lawyer and who didn't, technically, doesn't matter. You can say, when she filed it, I wasn't her attorney. This is when I came on board. Like, we don't need all this extra detail for this case because it doesn't matter. The judge doesn't care whether that person had an attorney or not. They would like to know when your relationship with this client started, in my opinion. Claimed while the paternity case was pending, she either had a miscarriage or otherwise learned she was not pregnant. After learning that information, Laura filed nothing further in the case, and the court administration set the case for dismissal due to inactivity. During that time, Mr. Eckerd was pro se. He was not represented by counsel. Shortly before the case was administratively dismissed, Mr. Eckerd hired counsel who appeared in the case around mid-December 2023. In his initial pleadings, Mr. Eckerd's lawyer accused Ms. Owens of fabricating her pregnancy. As a result, Mr. Eckerd's counsel threatened to seek sanctions against Laura for violating Rule 26. Oh my God, sir. You had to mention it one last time, didn't you? Of the Arizona Rules of Family Law Procedure, which is substantially identical to Rule 11 of the Federal Rules of Civil Procedure, i.e., it prohibits groundless pleadings and allows sanctions for violations subject to the safe harbor period in which an alleged violation may be cured. The rule also precludes an award of sanctions if a violation is timely cured within the safe harbor period. Although I did not represent Ms. Owens at the time, my review of the docket reflects that after Mr. Eckerd's counsel threatened to seek sanctions, Laura retained a different attorney who immediately sought to invoke the safe harbor rule of 26 by moving to dismiss Laura's paternity petition with prejudice underlined. The motion filed December 28, 2023, is available through the Arizona Court of Appeals website here. Despite Laura moving to dismiss her petition with prejudice just days later, on January 3, 2024, Mr. Eckerd's counsel filed a motion for sanctions pursuant to Rule 26 of the Arizona Rules of Family Law Procedure. That motion is available here. The court later denied requests to dismiss her petition, and the court set an evidentiary hearing on Mr. Eckerd's motion for sanctions on June 10, 2024. I was retained to represent Laura on March 25th, 2024, and appeared the same day. And then he has a link to that. After I appeared in the case, I learned that Mr. Eckerd disclosed several witnesses, including a man named Mike Maricini. According to Rule 49 of Arizona Rules of Family Law Procedure, all parties in family courts are required to disclose certain information to the other party, including the following: disclosure of witnesses. Each party must disclose the names, address, and telephone numbers of witnesses whom the disclosing party expects to call at trial, along with a statement fairly describing the substance of each witness's expected testimony. Emphasis added. The Arizona Supreme Court has interpreted this disclosure requirement to require specific disclosure of the substance of witness testimony, not generalized non-substantive references such as saying the witness will testify to all matters. Well, that's not what they told you, so you're being disingenuous here. And then he cites a case finding disclosure statements did not contain sufficient detail to comply with the rule, whereas simply stated witnesses would testify about all matters referred to in the deposition or all matters in the complaint of which the witness has knowledge. And this is why Omar, in one of his things, posted, this is what they said Michael Maricini was going to testify to, and from that filing, because Gingras sits there and says, well, I didn't know what he was going to testify. They just said he was just going to testify to all these things about the relationship. Like, no, he told you specific topics. Also, Mike Maricini also responded to you himself and told you. So when you were saying this, you're just flat out not being truthful. Holding adequate disclosure should fairly expose the facts and issues to be litigated, as well as the witnesses and exhibits to be relied upon. Based on my review of the disclosures provided by Mr. Eckert, it was clear his disclosures failed to meet the specific requirements of Rule 49, because Mr. Eckert disclosed literally nothing more than a single sentence suggesting Mr. Maricini intended. Yeah, no, that's not what they said, but okay, keep lying. We don't know what that single sentence is, because apparently pages 4 and 5 are blank or redacted for some reason. I don't know why. So it skips ahead to page 6. The new disclosure was directly contrary to what Ms. Pollock had told me just days earlier. Based on this, I became extremely concerned. So I again contacted Ms. Pollock by phone on May 6, 2024 to seek clarification. During the phone call, Ms. Pollock was extremely angry, defensive, and agitated. I found this extremely odd because my single prior conversation with her was exceptionally brief and cordial. During the call, I told her that if Mr. Maricini intended to appear as a witness, that was fine with me. I explained I had no concerns with Mr. Maricini testifying as long as he complied with the disclosure requirements of Rule 49 by providing a specific summary of his expected testimony. But see, the thing is you don't get to fully make that call, because what you see as sufficient and what the judge sees as sufficient might be two different things. You may not agree with her. Also, your version of events is inaccurate. So you saying, I don't think they have met the requirements of this rule and therefore it's not a valid subpoena and he shouldn't actually be here, that's not your call. That's the judge's call. The judge obviously thought everything was met, and you're just doing things on your own because you think you are the ruler and all-knowing God. I was also informed, Ms. Pollock, that Ms. Owens had a valid existing restraining order from this court, which required Mr. Maricini to remain at least 100 yards away from her at all times, and to otherwise not have any contact with her without prior permission from this court. But yet you were okay with letting your client talk to her, or talk to Mike, knowing that he needed permission from the court. Like y'all were setting him up to violate his restraining order. I don't think that's ethical as a lawyer. I told Ms. Pollock several times that I had no objection whatsoever to Mr. Maricini testifying in Arizona, provided he did so in the manner that complied with the Arizona rules and did not violate this court's order. As to the issue of disclosure, during the phone call, I asked Ms. Pollock whether Mr. Maricini would agree to either an informal interview by phone or deposition, assuming he would not agree to an interview. In response, Ms. Pollock specifically told me, no, we are not willing to cooperate with you. I responded by telling Ms. Pollock that compliance with Arizona rules was not optional, and that if Mr. Maricini would not agree to be interviewed or deposed in violation of Arizona's disclosure rules, then I would object to his participation at trial as the rules expressly allow. Yes, you're allowed to object. You're not allowed to threaten and intimidate because you think you know more than the judge. Well, whether you do know more than the judge or not, you're not in charge, sir. 25. In response, Ms. Pollock told me that under no circumstances would Mr. Maricini agree to comply with the Arizona procedural rules applicable to witness testimony, but instead he was planning to simply show up in Arizona as a non-subpoenaed spectator. Except for that didn't happen because he was subpoenaed. I found Ms. Pollock's remarks extremely disturbing because, among other things, Mr. Maricini threatened to travel from California to Arizona for the purposes of violating the court's order and appear to constitute a prima facie federal crime in violation. Well, see, he didn't actually do that, and you know that he didn't actually do that. And Maricini may not have said those things. I don't even know if Ms. Pollock said those things. Um, To ensure that there was no confusion about my position on these issues, immediately after speaking with Ms. Pollock by phone, I sent her an email on May 6, 2024. A true and correct copy of this email is attached here as Exhibit A. In this email, I documented my conversations with Ms. Pollock, including each of the above points. I also attached copies of the original and renewed domestic violence restraining order entered against Mr. Maricini by this court. In addition to repeating my position, i.e. that Mr. Maricini was obligated to comply with the disclosure requirements of Arizona law, is it just Arizona law for civil or is it family law? Because they're different. If he wanted to testify as a witness at trial, I also explained the following points. Well, this wasn't a trial, this was a hearing. Also, and just to be clear, I am not under any circumstances suggesting Mr. Maricini should not participate in the trial if he has relevant information. All I'm saying is that if he wants to testify, he needs to do so in a manner that complies with the rules and law. This is mandatory to ensure basic fairness to all sides. Finally, please note that it is a felony under Arizona law for any person to unlawfully withhold testimony, to evade legal process, to appear, and or to fail to appear when legally summoned. For avoidance of any doubt, nothing in this email should be construed as an attempt to cause Mr. Maricini not to appear. On the contrary, I would like very much for him to appear, provided he does so in yet another blank page. So now we're skipping to page 9. The sole subject of the Berryhill report was the laptop allegedly provided to him by Mr. Maricini. According to Mr. Berryhill, the laptop contained nearly 2,500 pages of private text messages exchanged between Mr. Maricini and Miss Owens while they were dating in 2016 to 2017. When I saw the Berryhill report, I was astonished because it represented such a blatant and intentional violation of family law disclosure rules. Bearing in mind that Owens v. Eckerd was filed on August 1st, 2023, the rules required Mr. Eckerd to promptly disclose all evidence he intended to use at trial. Rule 49 specifically required Mr. Eckerd to make his initial disclosures within 40 days after his initial response to the petition, which would mean by September 23. Any supplement disclosures were required to be made in a timely manner, which the rule defines as in no event more than 30 days after the information is disclosed or revealed by disclosing party. The thing is it was disclosed within 30 days of them receiving this laptop and getting this information. Like, this was all done real quick. So the fact that he is like, well, they should have known about this and it should have been disclosed way back when. They didn't know about it way back when. Maricini didn't even realize he had this laptop until he realized he had the laptop. And then within a few days, our cult, the Justice for cult, he went and had it forensically examined. And then the report was handed over to Woodnick, and then they handed the report over to you. All timely disclosed. Here, rather than complying with the disclosure obligations, it was obvious Mr. Eckerd and Mr. Maricini conspired to withhold and conceal evidence from Miss Owens. No, they didn't. And also, Miss Owens should have all this because she did this herself. And myself until literally 3 days before the close of discovery. Oh, well, we got it in the discovery deadline, but it was 3 days before the end of discovery. It doesn't matter if it was on the last day or the last hour of the window of discovery. You got it within the deadline. Immediately after receding, the court had previously scheduled the close of discovery as May 10th, 2024. Immediately after receiving some similar disclosures relating to Mr. Maricini, which were sent a few days before the full Berry Hill report, I filed an emergency request to strike Mr. Eckerd's pleadings and request for an immediate telephonic scheduling conference to discuss Mr. Eckerd's violation of disclosure rules as related to Mr. Maricini. Here's that filing. Unfortunately, despite seeking emergency relief, the trial court waived several weeks before denying my emergency request without explanation on May 21st, 2024. Judges don't have to give an explanation. They can. Sometimes they do, sometimes they don't. If you're in Massachusetts, she just writes on the page and just says denied or approved. Like, she don't even give certain reasoning. Sometimes she does, but sometimes they don't. Once it became clear that Mr. Maricini intended to violate his court's order by traveling to Arizona to appear at a hearing on June 10, 2024, without lawful grounds for doing so, the judge subpoenaed him and said he needs to be there. Whether you think he has lawful grounds for doing so or not is different. Laura told me she did not believe she could participate in the case unless we did everything possible to ensure Mr. Maricini complied with the court order. Well, he had, and the judge said he had. So that was good enough. You two don't get to decide that. To comply with Laura's request shortly before the June 10th hearing, I contacted Maricopa County Superior Court Security Department to advise them of the situation and to seek their assistance. I was told by the head of security, Officer Sean Gibbs, that he understood the situation and that court security would happy to ensure compliance with any valid court orders. Officer Gibbs asked me to provide him with a copy of the court's restraining order against Mr. Maricini, which I immediately did. On the morning of June 10th, 2024, Laura told me that she saw Mr. Maricini violate this court order by coming less than 100 yards away from her in the parking lot outside the courthouse. Laura told me that if Mr. Maricini was allowed to violate his court's order and harass and threaten her in any way, she did not believe that she could participate in the hearing set for 9 a.m. that morning. Well, he wasn't there to harass or threaten her in any way. He was there because he was subpoenaed. At Laura's request, I contacted court security to explain the situation and asked them to enforce the court's order. The court security told me they did not believe they had authority to enforce an out-of-state court order, and the only option for help was to contact Phoenix Police Department, which I immediately did. I wonder if we have one of these court security officers to say, I did not say that to him. Like, is that one of the witnesses that's going to be like, no, he's a liar? I said this. Officers from Phoenix Police Department arrived within a few minutes. At that time, I provided them with a copy of this court's order, and I explained that Mr. Maricini had violated it by coming within 100 yards of Miss Owens. I then asked them to enforce the order as required by federal law. And let me guess, everybody wants to just disregard the law because nobody wants to help Owens because everybody's against her for no reason. She's just a victim in all of this. Ugh. Responding officers told me they would defer my enforcement to the decision of the trial judge, Honorable Julie Mata. He can't even write out honorable. I get that he wants to, like, he kind of has to say it, but he's like, you know what? I'm not even going to write out honorable. I'm just going to say honor. Because he has so much disdain for her for, to me, no reason. But anyways, after some delay, the officers informed me that Judge Mata had instructed them not to enforce the court's order. The officers declined to offer any further explanation. Well, they don't have to. The judge said no, the end. And the judge is the person in charge. Shortly before the evidentiary hearing began, I again raised the same issue with Judge Mata, and I told her my view was under federal law, specifically 18 U.S.C. 2265. She was required to give full faith and credit to this court's order by enforcing it as written. Unfortunately, Judge Mata denied the request without any explanation. Once again, she doesn't have to give you an explanation. Also, you have to think about in family cases and DVRO cases, which you don't really work on, Gingras, that you cannot, like, people have to go against each other in court, especially um, in cases where someone has a restraining order and then their opponent that they're suing is the person of that. Well, the person that they're suing, they can't just be like, well, they can't be here at court to defend themselves and offer what they need to the judge because I have a restraining order. That is not how that's viewed. Um, because, oh my God, that would be what Owens wants. These people are not allowed to come testify against her. They can't bring anything in. Anything. Maybe it should have been done on Zoom. I don't know. But it wasn't. He had a subpoena to be there legally, and nothing happened, and the court made sure nothing happened. So he says, thereafter, Judge Mata allowed Mr. Maricini to sit in the small courtroom approximately 20 feet away from Laura. Mr. Maricini did not, in fact, testify as a witness, and Mr. Eckerd's counsel never obtained a valid California subpoena requiring Mr. Maricini to travel to Arizona for his appearance. I don't know if they have to have a California subpoena for an Arizona subpoena. That is something I don't know. Omar would know more about that. Similarly, Mr. Berryhill never testified as a witness, and his expert report was never admitted in evidence. Despite this, I am informed that the full 2,500 pages of text messages appended to Mr. Berryhill's report were later leaked onto the internet by either Mr. Maricini, Mr. Eckerd, or someone else working with them. Okay. We're allowed to have access to that report. Whether it was admitted or not, we're allowed to have it. Like, when Laura took the witness stand, she was forced to look at Mr. Maricini sitting approximately 30 to 40 feet in front of her for the entire duration of her testimony. During questioning and cross-examination, Laura became so upset she lost her composure and was unable to continue. As a result, I called for a recess, which was granted. The thing is when you watch this section where she needed to take a break in the video of the court hearing, which the judge would be able to see if Omar is like, here's this section. She got upset because of something somebody said in the crowd, which was not Maricini. It was not because she was having to look at him and be near him, because she was just fine on direct. But all of a sudden during cross is when she gets upset. During the recess, Laura, her mother, and our medical expert, a retired doctor, assembled in a side room. Laura was shaking almost uncontrollably, and she told me that she did not believe it was possible for her to continue testifying with Mr. Maricini sitting there glaring at her. I don't believe this. After extensive efforts from myself and our medical expert, we were eventually able to calm Laura down enough that she was able to complete her testimony, but it was clear to me that the traumatic nature of the situation directly affected Laura's testimony and demeanor in court. Based on my personal observation of Laura and discussions with her on June 10, 2024, I have no doubt that Mr. Maricini's actions that day were extremely upsetting to her. I believe Laura is partially concerned with Mr. Maricini knowingly and intentionally violating the court's order by traveling to Arizona for the purpose of harassing her, despite knowing in advance that doing so constituted a serious federal crime. He was there on a subpoena. What was he supposed to do? He did not go there to harass Owens. Pursuant to 28 U.S.C. 1746, I declare under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. So here's where he says it's true and correct. And then he signed it July 8th, 2025. And here we have the state bar messaging Maricini after he filed his bar complaint, which we have gone over the bar complaint in the in other videos. I am going to try to link those videos if you have not seen them in the description box. So there might be a bunch of different links to things that we refer to in this that we've already gone over. But on August 15, 2025, it says, Dear Mr. Maricini, we have completed our investigation into the matter listed above. Okay, so they completed their investigation, which means that it is possible that Gingras loses his bar card in the middle of this case. And then Laura is also left without an attorney. So whether he loses his bar card or gets disqualified and he quits, she still ends up with no attorney. After our investigation, we have decided to recommend to the Attorney Discipline Probable Cause Committee, ADPCC, the following disposition of the matter, order of probable cause. We thoroughly investigated this matter. We included reviewing the charge, Mr. Gingras' response, and Mr. Gingras' supplemental responses. We assume that as a complainant, you do not object to our recommendation. Nevertheless, you have the right to object if you choose to do so. He ain't objecting. Gingras crossed the line, and he knows he did. You must address your objection statement to the members of the Attorney Discipline Probable Cause Committee. You can prepare it in a letter format. Please mail or deliver your statement to my attention so I receive it at the State Bar by September 3rd, 2025 by 3 p.m. We will provide your objection to the committee with other information related to the bar's investigation. No extension of time period for submitting your written statement can be made unless substantial good cause is shown in writing to me. Thank you for your cooperation. And then it's signed a senior bar counsel. And then they also include the letter from Gingras from May 8th, 2024. These are other exhibits. And then it's the email to Greg, and and it goes through, we're in the process of looking for our own computer forensic person. Laura wants to move forward that review, and while I'm not confident it will change anything, I do think it may help her remove doubts about what the laptop shows. She shouldn't have any doubts about what it shows because she knows what she's done. She may be trying to play dumb, but she knows what it says. She just needs it to keep up with her act. And then the highlighted thing, one last thing, after talking with Laura about this, she said she has lots of questions for Mike. I told her my preference to have her send me any specific questions and see if Mike wants to answer them. She also said she's willing to speak directly with him, but that may not be appropriate in light of the restraining order. Correct. I'm glad you said it's not appropriate, but the fact that she still wants to me, shows she's not scared. She is okay with talking to him, and you would arrange it if it was allowed. That's unethical. On the other hand, if Mike has a strong preference in favor of directly speaking with Laura, which he doesn't want to, because he wants nothing to do with her, maybe we can make that happen. I'm licensed in California and can probably do some sort of stipulation with Randy to modify the CA order to allow this, just to be safe. Mike's not going to allow this, and neither is Randy Supalik. Then P.S., it goes without saying, but to the extent I suggested Mike would be arrested if he comes to court in Arizona, the suggestion is completely and totally withdrawn. I only said this because I wanted Mike to show up I didn't want Mike to show up without giving me a chance to at least interview him as far as I would any witness. Things are different in a family law case. And the fact that it's not a trial, it's just a hearing. It's an evidentiary hearing. I don't know that you get to depose somebody for an evidentiary hearing because I'm not a lawyer, so I don't know. I'll stipulate and agree his appearance in Arizona is not a violation of anything and will not expose him to arrest or any other legal questions if he agrees to have a reasonable call. So if he does this, I won't do this. I will say it's not a violation. Once again, you don't get to decide these things, Gingras. Then there is Exhibit E, which is response/objection to petitioner's motion in limine. filed on May 7, 2024. Exhibit F, blog by Gingras, Let's Talk About Lies, Part 2, May 2nd, 2024. Exhibit G, Maricini's depot transcript, 6/13/18. Gingras shared on Twitter on May 2nd, 2024, and it goes with the blog that is posted in Exhibit F, which we did not go over the depot transcript here. And because we did not think it was appropriate for Gingras to have done that. We did go over his blog post. We did go over the response objection to petitioner's motion in limine. And then for exhibits H through R, I'm going to make a separate video going over those. A lot of it is tweets and things like that and comments that Gingras makes in his blog posts that was on his website, which is now removed, that we haven't gone over before. And our quote of the day: when a toxic person can no longer control you, they will try to control how others see you. The misinformation will feel unfair, but stay above it, trusting that other people will eventually see the truth just like you did. I think it's fitting. Mike Maricini has stayed above it, and eventually people have seen the truth just as he has known the truth for all these years. And it is unfair, and it is a bunch of misinformation. But Owens's reputation and her image is ruined. So now she has to try to fix it by ruining other people because she can't look inside herself. She can't be the person. She is the toxic person. And she's losing control and she doesn't like it. So she has to do something. Blame other people instead of looking inside herself. So, if you know people like this, try to get away from them. You don't have to become a toxic person with them. That's going to be it for this video, and I will see you in the next one.